What if the person sitting across from you knew about a murder and legally could not tell anyone? Not the police, not the victim's family, not the public. They know how it happened. They know when it happened. They may even know where the body is. And yet, they remain silent. What if that silence wasn't corruption, wasn't greed, cowardice, or moral failure, but duty? A duty enforced not by personal loyalty, but by the very foundation of the legal system. Today, we're diving into one of the most uncomfortable corners of the law, a place where justice and morality don't always align. Lawyers who knew their client was a killer and kept the secret. For many people, this idea is deeply unsettling. It feels like betrayal, like complicity, like helping someone get away with the unthinkable. After all, if someone admits to murder, shouldn't the truth come out? Shouldn't the victims' families have answers? Shouldn't justice mean honesty at any cost? But the law doesn't always ask what feels right. It asks what protects everyone. This is not a story about villains in expensive suits or shadowy deals made behind closed doors. It's not about lawyers who lack conscience or who celebrate crime. It's a story about ethics under pressure, about trust that must exist even when it hurts, and about a rule so powerful and so controversial that without it, the justice system as we know it would collapse. That rule is called attorney-client privilege. It is the reason a lawyer can hear a confession and still stand in court arguing for their client's rights. It is the reason defendants can speak freely, without fear of immediate punishment. And it is the reason some truths remain buried. Not because the law doesn't care, but because it cares too much about the consequences of forcing them into the open. To understand why lawyers sometimes keep killers' secrets, most people assume lawyers exist to help find the truth. That's only partly true. A defense attorney's primary obligation is not to justice in a moral sense. It is to the client and to the legal process itself. At the heart of this obligation is something called attorney-client privilege. This rule means that anything a client tells their lawyer, confessions, details, even admissions of guilt, must remain confidential. Without this rule, the entire legal system collapses. Why? Because if clients feared their lawyers would turn them in, they would lie or stay silent. And without honesty, there can be no defense. Without defense, there is no fair trial. Without fair trials, there is no justice. But here's where it gets disturbing. Attorney-client privilege still applies even if the lawyer knows the client committed murder. Let that sink in. A lawyer can hear a full confession, not a suspicion, not a rumor, but a detailed account of how a life was taken, and still be legally bound to silence. They cannot report it. They cannot share it with police. They cannot tell the victim's family. In many cases, they cannot even reveal the location of the body. To the public, this feels impossible to accept. It sounds like aiding evil, like placing procedure above humanity, like allowing technical rules to override moral responsibility. But the law sees it differently. The purpose of attorney-client privilege is not to protect crime. It is to protect communication. The legal system assumes something crucial, that the state, with all its power, must be challenged. Police investigate. Prosecutors accuse. The government seeks punishment. The defense exists to test that power. And to do that effectively, a lawyer must know the full truth, even the parts no one else should ever hear. If privilege disappeared the moment a client admitted guilt, defense attorneys would become investigators for the state. Clients would withhold information. They would distort facts. They would make their own defense weaker and the system more dangerous. Because once a lawyer cannot be trusted, no one can be defended properly. And the law is designed around a radical idea. It is better for some guilty people to go free than for the system to become one where the innocent cannot be protected. That principle is hard. It is painful. And in cases involving murder, it feels almost unbearable. Yet it remains one of the pillars of modern justice. The lawyer is not there to decide guilt or innocence. That role belongs to the judge and the jury. The lawyer's job is narrower and heavier, to ensure the process is fair, even when the truth is ugly, even when silence feels wrong. And that silence, however troubling, is not a loophole. It is the rule. Imagine this scenario. A man is charged with murder. There's no body, no confession, circumstantial evidence at best. Behind closed doors, he tells his lawyer everything. Where the body is, how it happened, why he did it. Not as a hypothetical, not as a half-truth, but as fact. The lawyer now knows the truth and must act as if they don't. They cannot reveal the confession. They cannot assist police. They cannot disclose the location of the body, even if that information would bring closure, even if it would end years of searching, even if it would confirm what everyone suspects. And perhaps the hardest part of all, they may still stand in court and do their job. They may challenge the prosecution's evidence, cross-examine witnesses, point out flaws in the investigation, argue that the case does not meet the legal standard of proof. They may even argue for acquittal. To many people watching from the outside, this feels like helping a killer walk free. It feels like betrayal of the victim, of the family, of basic human decency. But legally, it's not. It's protecting the system. Because the courtroom is not a place for hidden knowledge. It is a place for evidence. What the lawyer knows privately does not exist in the eyes of the court. Only what can be proven, lawfully, transparently, and fairly, matters. And that distinction is deliberate. The legal system is built on a dangerous idea that the government must earn its power to punish, even when the accused is guilty, even when the truth is known in private. The moment we allow secret knowledge to influence public outcomes, we create a system where fairness depends on who knows what, not on what can be proven. And that is a system ripe for abuse. So the lawyer becomes something many people struggle to understand. Not a seeker of truth, but a guardian of process. They are not there to correct moral wrongs. They are there to prevent legal ones. And that role comes at a cost. Defense attorneys in these situations often describe the experience as isolating. They carry knowledge they cannot share. They hear grief they cannot relieve. They are judged for actions that are not personal choices, but professional obligations. Some are vilified in the media. Some receive threats. Some are remembered not for the system they upheld, but for the outcome people couldn't accept. Yet if that lawyer broke confidentiality, even once, the precedent would ripple outward. This isn't hypothetical. One of the most famous and controversial examples occurred in Canada. In the 1990s, a defense lawyer learned something that law enforcement desperately wanted to know: the exact location of murder victims' bodies. Information the police did not have. Information that could end years of uncertainty. Information that grieving families were begging for. The lawyer knew, and the lawyer stayed silent. Not because of indifference, not because of cruelty, but because the law demanded it. Behind the scenes, the tension was unbearable. Families pleaded publicly for answers. Investigators exhausted every lead. The absence of the bodies haunted the case and the nation. Many assumed there had to be an exception. Surely, human remains would outweigh legal technicalities. Surely, compassion would prevail over procedure. But the law doesn't bend easily, especially when its foundations are at stake. The case climbed through the courts, each level wrestling with the same impossible question: does the need for closure override the right to a fair defense? Eventually, it reached the Supreme Court of Canada, and the ruling shocked many. Attorney-client privilege, the court held, is nearly absolute. So strong, in fact, that even the location of human remains does not automatically justify breaking it. The court reasoned that once exceptions begin, the privilege begins to erode. If bodies justify disclosure, why not weapons? If weapons, why not motives? And once that door opens, clients can no longer trust their lawyers, and lawyers can no longer do their jobs. In the court's view, this wasn't about one case. It was about preserving a system designed to protect everyone, especially the most vulnerable. The public reaction was swift and fierce. Newspapers called the decision heartless. Commentators accused the courts of valuing criminals over victims. Families of the yes, but they are extremely narrow. A lawyer may break confidentiality if the client plans future harm. There is an imminent threat to life. Disclosure is necessary to prevent serious injury or death. Notice the key word: future. If the crime already happened, even something horrific, the lawyer must remain silent. The system draws a hard line between preventing harm and punishing past acts, and many lawyers live with that burden for the rest of their lives. The moral weight lawyers carry. Defense attorneys often describe this as the hardest part of the job: knowing the truth, seeing victims' families grieve, while saying nothing. Some quit, some seek therapy, some convince themselves that their silence serves a greater good. Others never fully make peace with it. But here's something rarely acknowledged. Defense lawyers don't decide guilt. Juries do. Judges do. The legal system is designed so that no single person carries that responsibility alone. The lawyer's role is not to decide who deserves punishment, but to ensure the state follows the rules. Why this rule protects you? It's tempting to say, if someone admits murder, the lawyer should be forced to tell. But consider the consequences. What if police could pressure lawyers? What if political dissidents couldn't speak freely? What if innocent people feared confiding in counsel? History shows us that once confidentiality erodes, power fills the gap. Attorney-client privilege protects the innocent accused, whistleblowers, victims of abuse, anyone facing the state's power. Even when it feels unjust in individual cases, it prevents far greater injustice overall. So the next time you hear about a lawyer defending someone they know is guilty, ask yourself, do you want a system that only works when people behave well? Or one that protects rights, even in the worst cases? Because the rules that shield the guilty today may save the innocent tomorrow. Here's the uncomfortable truth. A just system must sometimes allow outcomes that feel unjust. That paradox is the price of fairness. The moment we allow emotion to override procedure, we replace law with vengeance. Defense lawyers who keep killers' secrets are not endorsing the crime. They are standing between absolute state power and individual rights. And that line, however thin, matters. For more criminal stories like this, stay connected with us. Subscribe to the channel, like the video, share it, and don't forget to press the bell icon.